Dangers of asset protection strategies. The concept of asset protection tends to evoke the perception of an impenetrable legal fortress safeguarding wealth from unforeseen creditors, litigious adversaries, or even the taxman. While the desire to preserve hard-earned assets is entirely legitimate, the legal landscape surrounding such strategies is far from a straightforward path. Without a comprehensive understanding of the inherent risks and complexities, what appears to be a prudent defensive measure can quickly transform into a legal quagmire, exposing individuals to severe penalties, civil liabilities, and even criminal charges. The line between legitimate financial planning and illegal asset concealment is often thin and easily transgressed, making expert guidance not just advisable, but essential. One of the primary legal dangers lies in the potential for asset protection strategies to be deemed fraudulent conveyances or preferences under provincial fraudulent conveyance legislation or the Federal Bankruptcy and Insolvency Act. These laws are designed to prevent debtors from transferring assets out of their reach to avoid paying creditors. If a court determines that an asset transfer was made with the intent to defraud creditors, or that it unfairly preferred one creditor over others, the transaction can be set aside. This means the assets can be clawed back into the debtor's estate, effectively undoing the protection and leaving the individual in a worse position, often facing additional legal costs and scrutiny. Beyond the unwinding of transactions, individuals engaging in questionable asset protection tactics may face personal liability. Directors of corporations, for instance, can be held personally responsible for the debts of a company if they are found to have engaged in fraudulent transfers or other improper conduct to shield corporate assets. Similarly, individuals who advise on or facilitate such schemes, including lawyers or financial advisors, could also face professional misconduct charges, civil liability, or even criminal prosecution if they are deemed to have aided and abetted fraudulent activities. The legal net can cast wide, ensnaring not just the asset owner but also those who assisted in the strategy. The tax implications of poorly executed asset protection strategies present another significant hazard. Many strategies involve trusts, offshore accounts, or complex corporate structures, each carrying specific reporting requirements and tax treatments under the Income Tax Act. Failure to properly declare assets, report income, or comply with anti-avoidance rules can lead to substantial tax arrears, interest penalties, and severe fines. The Canada Revenue Agency has sophisticated tools and extensive powers to uncover undeclared assets and income, and they are increasingly aggressive in pursuing individuals and entities engaged in tax evasion or aggressive tax avoidance schemes that cross legal boundaries. Furthermore, the involvement of offshore jurisdictions, while seemingly offering an additional layer of secrecy and protection, introduces a host of international legal complexities. While legitimate international planning exists, using offshore entities solely to hide assets from Canadian tax and financial authorities or creditors can trigger anti-money laundering laws, anti-terrorism financing regulations, and international tax treaties. Canadian tax and financial authorities actively collaborate with international counterparts to combat financial crimes, making it increasingly difficult to truly hide assets abroad. Individuals found to be in breach of these regulations could face not only civil penalties but also criminal charges with international implications. Ultimately, the allure of absolute asset protection must be tempered with a realistic understanding of the robust legal frameworks in place to prevent abuse. Canadian law prioritizes the rights of legitimate creditors and the integrity of the tax system. Any strategy designed with the primary intent to illegally frustrate creditors, evade taxes, or conceal assets will likely fail and result in significant adverse consequences. Therefore, Canadians considering asset protection must proceed with extreme caution, seeking advice from highly reputable legal and financial professionals who prioritize compliance and ethical practices above all else, ensuring strategies are robust, transparent, and legally defensible. To learn more about our law firm's tax and estate planning legal practice, visit our website or contact our law firm to schedule a confidential consultation. Thank you.